Okay, sorry for that, again. Good evening, everyone. Can you all hear me?
Mhm.
All right. So please, we'll be starting very soon. Please just kindly give us 4 minutes to begin the session. Thank you.
Sorry, what did you say?
I couldn't hear the speaker who is. Can you just increase your volume? I'm unable to hear you. Yeah.
Hello, good evening. Can you hear me?
Yes, I can hear you. Good evening.
All right. Thank you very much for joining me for the session. Sorry, I'm experiencing a little technical issue on one, the other one goes off, but we would see how best we would go or handle it throughout the course of the class. So I want to quickly welcome all of us to today's session. Welcome everyone for the mentees. Thank you guys for joining. Please, like I earlier said, let's reach out to our other co-mentees to join in for the session. All right, so just to begin with, like like we did, we'll be introducing our mentor first, Mrs. OJ. Thank you so much for joining. We are happy to have you in the session again. Our topic for today is patent applications slash patent drafting, right? And I trust we'll be having a really wonderful session. So to introduce Mrs. OJS again, Mrs. OJ is a registered India patent agent. Is a registered um, Indian patent agent and attorney with extensive experience across the full life cycle of patent management, including patent drafting, filing, and prosecution. Her practice prosecution. Her practice is primarily focused on electronic and computer science domain. Beyond patent prosecution, she is passionate about promoting innovation through educational outreach and supporting inventors in identifying effective pathways for the commercialization of their invention. She currently operates as an independent practitioner, specializing in patent prosecution before the controller of the Indian Patent Office. In addition to her legal practice, she is actively involved in mentoring the next generation of intellectual property professionals aspiring by training aspiring patent practitioners in patent law and patent drafting. Her competence include patent drafting and prosecution, skilled in preparing patent specifications and managing prosecution processes in the Indian Patent Office, sector analysis, experience in freedom to operate analysis, patent landscaping, and prior acts such as educational training provides structured training and mentorship for individuals preparing for a career in patent law. Thank you so much, Mark, for joining. We are happy to have you in today's session. So we'll be starting the class right about now. We'll be starting the class right about now, and just like we did in the last session, we'll be receiving your discourse firstly. We will get to hear from you, share what you have prepared for us in class in the next 20 minutes, and then we'll go over to Mentee's presentation, and then from the Mentee's presentation, we'll take feedback from you based off of their presentations. We'll take questions, and then we'll call it a day. I trust you were able to follow up on that, Mark. So in the next 20 to 30 minutes, we just want to kindly give you the floor to give us your discourse into the topic for today, patents, applications, and patent drafting.
Um, Thank you so much. So, can I share the screen right now, my screen, so that I can quickly go with changing the slides on my end? Okay, yeah. Please, if you want me to stop in between or you want to ask any questions while I'm going, please do let me know. I'll stop. So for today's session, as we are talking in the previous session, we went for the search strategies. What are different search strategies and how we can do a simple live example we have given. So if I, before going with the drafting of the patent, because I will quickly go with another example of the search using eSpaceNet, because last session we were unable to do it. So let me quickly share that screen. Yes. So can you see a screen, eSpaceNet, the web page? Yes?
No, it's your slides are showing now.
Okay, one moment. Now, can you see?
Yes, now we can see it now.
Okay, so this one I have used eSpaceNet this time. So I just have uh, turned the advanced search, and if you can see, these are the fields which we have given. So this and or operators, these are the logical expressions which we give, and these are the keywords which we give between. So or is used when we want the documents which is either having biomaterial or organic, anything it can be. And is an operator when we need these two keywords to be present in a single document. So again, these two, if you could see, this gray box and the below gray box are again given with a common and operator. So this structure forms as biomaterial or organic, and drying and shim. So this is the logical expression. If you could see here, this is the logical expression which is above. Okay. And I have selected all text fields. So in the text fields, you can go and select all text fields so that it will cover the entire document. So it will not restrict its search to any certain specific area of the document. So if you see, these are the results. Now we have given a very broader search elements. So let's see what happens if I take off this. Only biomaterial, drying, and chamber I need. And let's search for this. The number of results have been changed. See, from 37,000, it came to 5,000 only. So it depends. So you have to give very accurate keywords which match. So that's why I said all synonyms might not be useful for your patent application. So you have to recheck whether that synonym falls within the technical technology of your patent or of your idea or invention. Then only use those terms, or the search will get complicated. So here again, if you just click on this, it will, you can, how to do this? My screen is, yeah. So it has a 3-space window. One moment, guys. Yes. So if you could see, this is the application. These are the priorities. So you might ask, what is priority? So these are the number of applications which are filed before this existing document, which is relevant to the same content. So there might be provisionals or complete which have priority over this document. So all this application also contains a similar context what is disclosed in this document. And see, if you could see, this is the abstract. These are the figures. This is the bibliographic data. Now, if you go for the description here, you could see the description in the English or whatever language you want, you can select it. There is an option of patent translate, and you can select the language in whichever language you want. And you can see the keywords which we have given here are already being highlighted here. So that's what actually in the previous I was saying this is a good search window because it highlights so that we can quickly go and just check the lines where the keywords are highlighted. So it reduces our read time also. So this is the description. You can just go with the claims, and coming to the claims, you have claims. Okay, these are the claims. And if you again you want original document, this will be your original document. Okay. And so this original document, actually, you can download it. You can download the original document here. So these are the facilities what you can go with eSpace. So if you want, I can give some exercises if needed. You can just let me know. I'll give some search exercises. You can just try out in eSpaceNet in the similar way. So it's very simple. Keep your keywords. Use proper Boolean operators. Boolean operators means and or. Okay. So the similar context will be separated by and something different, like see a drying and chamber. These are, you have to place it in a different text fields, because you cannot come, I mean, if you combine drying here, chamber, sometimes it will give only the documents which has both drying chamber together. But we might miss the documents which has separate entities. And actually, if you remove this chamber also, see biomaterial drying, if you go with this search keywords, the results might differ. It will have both product and process, because we are talking about drying. So it can be either a device claims or process claims. But when I have given chamber, we are talking about only the device. So the results have come very less number. So you just play with the keywords however you want here, and you can just check this is the actual search operator, search query which we are giving to this database. So whatever you type here, automatically it will be generated, and you can see the results. All the keywords are highlighted. You can click on it. You just check text by, and you can also download the original document if you feel that it is relevant document. So this is one of the example. Now coming back to the today's presentation, quickly we'll go through because we have less time, we have to listen to the mentee's presentation also today. Please let me know if you are unable to hear or the screen is not moving, because I find that there is some discrepancy, because if anyone you're owning your camera, your image is not at all moving. It's like struck for me. So that's why I'm asking you again and again. So for today's, we are going with the description. I mean, the drafting of the patent document, except the claims part. Okay, we'll cover that in the next upcoming weeks. So today we are going to cover the main, I mean, the technical part of the document. So as I said, your patent document is a technical plus legal part. So the claims are the legal part, and the other part is completely purely technical document. So where you should begin. So these are some of the criteria which you have to be aware of before you start for a search or for filing a document. So you have to identify a problem and a solution. So there might be already existing solutions which are not known to you of the problem which you have encountered. So better you search for the existing problems, if any. Okay, and then compare with with the solution what you came up. Is it better than those existing solutions which are there for the similar problem? Okay, then you can think about whether it is a process or a product. Okay, composition is generally for the pharmaceuticals, nothing much. So we'll give the exact weight by weight or weight by volume proportion of the each component or each elements which are existing in that formulation. So we'll give that in a proper, that I can show you some examples in the later slides. So now coming to this, a patent or non-patent prior art search to be conducted. Before you jump into the drafting, it's better. It is actually suggested to do this, because whatever efforts you're going to put in the drafting and filing and everything, that should not go waste. So coming to the next slide. So these are the different sections in the patent application. So first, the title, then the technical field, background, summary, drawings, detailed descriptions, claims, and abstract. So except claims, everything are technical. Okay. So now coming to the title of invention, there are some subtle, these are general, you can say suggestions instead of rules kind of thing. These are some suggestions which are followed by almost all the country, jurisdictions here. So it should be meaningful and don't give a lengthy description in the title. Okay, you can just put some sort of, okay, now many of them, now AI, artificial intelligence, machine learnings are very popular nowadays. So you can just mention that it is AI enabled system or device or a method. Don't go into mentioning the type of algorithms you're using in the title. So be very broader. Just introduce that, the technology. So now the AI and ML is a technology. So introduce that in your title, but don't go into depth. Don't give more description. And it's better if you keep it very concise and simple, like maximum 15 to 20 words is suggested, because don't put 15 words is also a lengthier one. So, and again, you can also introduce whether it's a system or a device or a system and method, both. If it's a composition, mention it as a composition. So just mention like a system to avoid pollution and method thereof. So now this one here is having a system which avoids pollution, and the method is the working of that system method. Okay, so how that system functions, the working method or the workflow of that system, that is the method it means. So now again, there are some things which you have to avoid, specifically the trade names, trademarks, or your own personal names or your company name. So don't put it, because in some scenarios, especially in the software companies, we observe that they already name their application or a software some XYZ, and they want to come with the title of XYZ. So you cannot put what is already a trade name or something of that application or software into the title. You have to give a proper, like what exactly it is related to. So these are some things which we actually follow. Now coming to the next topic is the technical field of invention. So what is a technical field of invention? You have to describe in which field, physics, chemistry, biology. So those are the general things. Now let's go into a depth, a second step. You can say now it's related to electronics. So in what electronics? Okay, it is an electronics patent, understood. So what exactly it does? So is it in some security systems kind of thing? Mention that also. So these are the some of the content which I have given in the yellow are some of the examples which are taken, extracted from already filed, published documents. Okay. So you could see how the field socket, that is water or airtight. Okay. So you have to give maximum 2 or 3 sentences. Don't go beyond that. That's enough. A very concise manner, but you have to introduce your product in those 2 lines. So these are some of the exercises. I think the slides are already changed. You can try coming up with the abstract, title, and field of invention for this. Okay. Now coming to the background of the invention. So now this background of the invention is the particular, does not exactly describe your invention, but it will introduce the technology. It will state the problem. It will state any existing solutions. That is, any existing solutions might be in the form of non-patent literature like articles or published documents somewhere, or website, journal, something, whatever it is. And later it is followed by some prior art in form of patents, if you have already conducted a patentability or prior art search before starting, you are beginning with the drafting of the application. And coming again, you shouldn't leave with that. You should also state reasons for a new solution, because you already cited some of the existing solutions in this prior art. So this prior art is something which is having different solutions or existing solutions, which might be similar to yours, but not 100%. So it might be, your solution might be some improvement over those existing solutions also. Okay. So now you have to state a need for the new solution. Then what is the advancements needed to the existing solutions. You can actually give proper limitations of the existing solutions here. Like this solution has benefit of this, but but there is a limitation that it cannot be applied for this or this or this. So those form of statements you can give, so that, and again you can say that whatever limitations are there in the above cited applications, patent documents, or existing solutions, this application or this invention is going to overcome those limitations. Okay, so that is the background of your invention. Okay, so where your prior art search comes handy is your inclusion in this background section of the patent. So you can include actually this article, the publication number, and what exactly that patent application is disclosing in a few lines, like 3-4 lines, close it off. So in this way, you have to go in a proper flow manner in the background section. So you should cover all these things. So it should have, you have to maintain that introduction, problem, existing solutions, what are the limitations of the existing solutions, what is the need for the existing, what is the need for a new solution over the existing solutions. So these are the things which you cover in the background. So you're not at all talking about your invention, but you're showing a need for a new solution which might be your invention. So now coming to the summary of the invention is where you start beginning explaining your invention properly in a very concise, very short notes kind of thing. So you explain some features, what it is having. So my device is having ABCD components, full stop. That is a paragraph. There's no need to give explanation or details about what is A, what is B, what is C. That you can go and describe in the detailed description. And objectives. You can come with the objectives like my aim. The aim of this particular system or a method is to solve this problem. You can come up with different objectives, line by line. And also you can give some alternate features of your products, like you might have trialed version 1, so you can say that you can just leave a scope that there might be, you cannot give a might be, there is also a chance for improvising this by using, instead of component A, I'm going to use A1 component. But the solution remains, but the end result will remain same. But A1 can also be utilized when component A is not available, component A1 can be used and the result will be same. So in such sort, and the best method, if you feel that there are multiple uses of your invention, okay, multiple embodiments, not uses, embodiments. In a scenario like what I said, like you can replace some components with other things. Now you can clearly state what is the best among all those replacements or combinations, what you feel it is best. That also you can in the summary. Now coming to the abstract, explain, you have to give all technical important points within 150 word frame, even single word extra. So it will restrict with 150. It will give an error message that you have it crossed 150. Please recheck the abstract kind of thing. It will allow, but later on again you'll get a official letter that to rewrite your abstract again within 150 words. So this might happen. So to avoid that, just try to draft your entire document, your entire technical aspects, your invention within 150 word claim. So this one, it also sometimes you can say it is similar to the summary, but in abstract we are not going to cover the multiple combinations, the best method, nothing. We are going to describe it in the field, what problem it is actually solving, what exactly it comprises, your device. It is a method, what are the important steps it consists of. That is the abstract, and 150 words, please remember that. And in abstract, sometimes if it is a device patent, you can also provide the related figure. So you can say refer to figure 1 or figure 1 in the abstract, so that what is the of the abstract solely because, and if you mention any figure in the abstract, that figure, this will be published first. Okay. And the later document, the entire document in the journals. Other documents will be actually, it will be retained in the portal, online portals. You can just check in the data. But the main thing which will be published in some patent journals is this abstract and the figure, which you refer it. So these are what I said. These are the simple, I'll not say rules, but these are suggestions. And 150 is something like, generally they say do not exist to 250 words. But if you go for the, I'm explaining because PCT portal, like I have seen, we are discussing about the PCT filing and everything. So 150 is the limited word limit for PCT. And in other country jurisdictions, mostly 150 we follow it. So here, these are another examples, like the abstract should be primarily directed to what is new in the art to which mention pertains. So don't talk about anything existing solutions or kind of thing which we have already done in the background. Okay, just talk about your invention here. There is no need to give a problem statement also in abstract. So unnecessarily you're putting a lot of words into it. So just introduce like, see, a device or a system related to this to solve this. And it comprises the main components A, B, C, D. And you can also give its advantages. Full stop. That's it. There's no need more because abstract is something which introduces it and you're actually describing the main components of it. You're disclosing the main components of it in the abstract. So it will give something, at least a general idea of what your invention is. But if anyone is introduced with the abstract, because in the journal, when they are referring to the journal, it will give a basic idea of what exactly it is. And in searches also, most times when we are quickly going with the prior art kind of thing, we depend on the abstract and the claims. So we do a keyword mapping with the abstract and the claims. And if we see there is some relevancy in the claims in the abstract, then we'll go into the detailed description and check whether that method or product is similar to the idea or not. So this also, it's actually, you will be helping other people when your document, you file today. Tomorrow someone will come with a similar technology. So your document will serve as a prior art to that person. So he'll also understand, okay, whether to go with filing after referring your document. So you just in 150 words. And so what is the difference between summary and abstract? As I said, we're not going to give multiple combinations or best method, nothing. We're not going to put all that in the abstract. Now, drawing. So this is the actual structure of the drawings where we put, so different views we can give in the drawings. And these are the reference numbers. So we have to label in this way. And in this detailed description, whenever the keyword, so now number 8 is the soul. Okay, so whenever we mention number in parentheses, soul keyword. So it is referred to the drawings to understand where the component is exactly placed, the placement he can have in this kind of products. So this is actually it's a car engine, a drawing, so it's very complicated. If you could see, it's really complicated drawing based on the numbering, if you could see. And coming to the requirements of drawings, these are some of the rules which generally we follow in any jurisdiction. It should be in black and white and strokes. Okay, but the main thing is it should be colors. We're not going with the colors. If you want to differentiate some sort of area, like this is different from this is different, use some textures like strokes to understand, okay, this is different, something different. And there is, we already disclaimed that they are not to the scale. So we cannot generally, so it's not up to the scale. So we just say, it's not given, like exact dimensions we're not going to mention in the drawings. So that exact dimensions are not at all suggested to mention either in the drawings or description. You have to leave some window like a range value. Where your exact value might fall within that range. So again, words in the drawings not allowed. For what kind? This kind. This kind of drawings, words are not allowed. But if you go with the flow chart, this kind of thing is allowed. Flow charts or block diagrams, especially for computer related inventions, when we are describing the application, software application, we generally go with the block diagrams to just point out the data flow between this. So from the input device, the processor, then the output device, how the data flows will give an arrow marks. So that is allowed. In these blocks, you can mention it. But again, outside, see, if you could see here, in this blocks only, there is a data. But near 14, 16, or there is another 30, if you could see. So 30 is actually indicating some sort of data flow. So between this 26 and 28, 30 is describing a data flow. So everything, if you could see. So it should be very less numbers, only restricted within the blocks. And numberings also, see, if you could see, when you mention the number in the description, it is a good practice to give list of reference numerals. So here, if you could see, we are mentioning this reference numeral is belonging to, explains this component, so component name is given. Now, different views. So for some inventions, especially the product inventions, we might, when we are describing, if it is outside structure, we just give this kind of views, isometric 3D views, and orthogonal means a 2D view, like front, back, side, two sides, left and right, and top and bottom view. That will be leaving off. When we are describing something null aspect, which is not visible to the eye, but which is inside the device, then we are going with the sectional view. So it is a sectional view. If you could see this kind of 21, whatever they are doing, that is, if we cut this part, the number 5 line is there, no? So there is a cross-sectional part. So if we cut the device, this is the design or arrangement is in this way. So if we seek some novelty within this, then we are going to give a sectional views and cutaway views. Mostly in physics related inventions, we go for this type of drawings. So cutaway views, exploded views. So exploded views actually generally explain that these all are arranged, the arrangement of it. So when you try to put it together, the object, this is the object. When you're actually removing it, separating it, so exploded view. Drawings. So drawings, you could see numbering, wordings restricted to that. It should be in black and white. Okay. Proper proportion needs to be maintained because we are not giving an exact scale kind of thing. And the list of reference numerals is also, it's a good practice actually. If you give before explaining the drawings, it's better you note it first and you can start immediately explaining each drawing, which has those reference numerals. Now this is the different views which requires, like if you see that your invention lies within, which is not visible to the eye, then go with sectional views, exploded views and everything. Now coming to the description. So the description part is something which includes all essential features, different embodiments, drawings needs to be explained, advantages and your application. So these are the 5 criteria which you have to put in together in the description. So what do you mean by embodiments? So for example, if you see one embodiment may describe how a headlight was made. Okay. Now, different variations can be happening in that making process of a headlight. So you can say second embodiment will have, third embodiment can have. Now you've seen, for an example, I have given this way. So everyone represent A has some hairstyle in a different one. and he likes to wear collar shirt kind of thing. But if you could see student, you can go with 7, likes to leave her hair and likes to knot a tie with the collar neck. So these are different variations. In the similar way, what I've explained previously, so your device having component A, B, C, D. So in place, okay, when A is not available, plus C plus D will give the similar results. So that is the embodiment, different version of your invention, but it's not deviating from the solution which you're providing. The solution will be same, but the combinations might differ. So some examples, like some tips in making more clear, it's better if you give some working examples if you have already trial and error that device before filing the application. If not, you can explain the working model, like how you assume, like this in this working pattern, if my device is worked in this way, then this will go, the performance is so and so. And if I make some modification in the working strategy in this way, the performance is better in this way. So this type of performance is preferred in this scenario. So it depends in whatever situation. You might not need, like as I said, when A is not available, A is available, then go with A1. So those kind of things, please explain that. And don't give a prophetic examples. Prophetic in the terms like it might happen, it can happen, it may happen, like you're leaving it like it may or may not happen in the future. You're giving a doubt, a vague answer there. So it's better that you give a proper, like in a present tense, like this particular device, it can be worked in a different pattern, so and so. So that means you're actually not 100% assuring it, but you're saying that it can be done. It may be done is something different, but it can be done is something different. So again, chemical structures and its varying compositions. So varying composition means, as I said, don't give the exact value. We are putting a range. Okay. So in one embodiment, you say that I want to use glycerol from, it can be from 30 to 60 weight by volume of the entire composition. Okay. Now in second embodiment, I will say glycerol can be used from 37 to 52. Now you see 37 to 52 is falling within the 30 and 60 which you have given the previous embodiment. You're not deviating from that. Or sometimes in some scenarios, it can deviate also when you say that the composition you're changing, somewhat you're removing some elements. You feel that when you replace one element, the other element is not needed. Then the glycerol quantity also might be increased or decreased. So you can do that also. You can give multiple variations. So this all will be covered into multiple embodiments. And sequence listing is something, the chemical formulas you have to represent it. There is a separate, you have to present in a separate sheet. It's not included within the description, but it should be given in a separate sheet. Like drawings also, it's not included. It is, they are presented in a separate document. So whatever the document, like while filing, you're filing two different documents, like the entire description and drawings as a separate sheets. In the similar way, the sequence listing also has a different format. Instead of Word document, it has a separate format, some kind of thing where you have to upload those chemical formulas properly. And coming to computer related or implemented inventions. So there are some suggestions where you have to avoid few words, especially in the claims. So don't put in the claims like program, instructions, algorithms. It's better to avoid because many jurisdictions are not considering these algorithms as a patentable subject matter. So it's better you avoid this. Instead of that, you can say an application or a computer related application. So be clear. There is no need to say that why to present something which is not there. Just use some alternate terms which are already like these particular things, especially as per our Indian Act. Algorithms is a strict no for us to use it in the claims. If we use it, like we'll get a clear objection and we have to amend the document and everything. So we avoid this particular algorithm word in the document when filing our Indian applications. And coming to keep method as independent claim, a separate independent claim, and separate dependent claims for each device should be given. So you will be having a first independent system or a device or a composition claim, and you'll be having dependent claims which are depending on that independent system independent claim. And again, if you feel that you want to disclose the method also, then that will add to a separate independent claim. We'll discuss what is this independent dependent in our next week session when we're talking about the claim language. And some additional tips here. So please try to provide all the explanations very detailed in very clear language for all the drawings, whatever. Don't miss any drawing. If you have, cannot be described as embodiments because there are use cases. And US, I think USA will allow use claims, but in India we don't allow use claims. Use claims is a scenario that it can be operated or it can be applied and so on. So that as a separate claims. In India, we are not, I mean, it's not allowable. But in US, use claims are allowed. Now, alternate methods can be referred as it should be, the values should be given as form, right? So don't, it's better not to disclose the same if you give us exact value. If you give some range, it will take a lot of time for them to come up with the exact form because they have to give multiple trials and errors. So better to avoid any competency, it's range format. That's it, guys. For today's, I have finished. So if you have any doubts, I'll quickly explain it, and then we'll go with the mentee's presentation. Any questions? I'm ready to.
All right, so please, do we have any question based off of what our mentor has presented in the class on the session? All right, I noticed we were going back and forth, so I believe network may be a challenge for some of us. The network may be a challenge for some of us, but I really, really hope that we are able to get a chunk of it. If you have a question, please, you can do well to ask your question now. No questions? Okay, thank you so much, Ron. We will be getting back to you very soon. I'm sure that once the presentations are over, we would also ask again if there are more questions so that we can get to take questions in the session. But now we'll be taking presentations from the mentees. Our good presenter, let's quickly go ahead. Share your slides, start your presentation, and we'll continue with the presenter in class. Please go ahead and share your slides.
Okay, good afternoon, everyone.
Yes, good
Can you
afternoon,
hear me?
Chani.
Okay,
Yes, we can hear you.
okay. All right, I would wait for you to share the PowerPoint presentation so that I can start.
Okay, I'm having a little issues from my end. My sharing may not necessarily be possible. Sharing may not necessarily be possible for me. So please, I want to ask if any of the members of the team can help Chenny share the slides while she presents on behalf of the group. Hello, can you hear me? Please, can we have someone help Jenny share her slides while we...
Sorry, I'm unable to share my slides because I'm actually in transit, so it's going to be like quite difficult sharing the slides. I'm so sorry about that.
All right, no problem. Let's see if we can work on something. But Jenny, please, you can go ahead and introduce yourself. That's the intro.
A moment, I think I received it. Let me open from my system and I'll share it. And you can let me know whenever you want to change.
All right.
I'll just change it. Let me just quickly check it out.
All
Give me a
right. Thank
moment.
you so much, ma.
Okay, I noticed she's no longer on the call. Uh, on my own, and I, I am quite surprised I'm moving it to work around bringing up my screen, but unfortunately, it seems to be very, very dicey. So let's see if we can have our mentor. When we have our mentor back, then we will go ahead and then we'll start your presentation. Sorry again about the delay. Welcome back, Ma.
Yeah, actually the window got stuck when I'm trying to open the presentation. Just give me a moment. Again, I'll try it. I couldn't open it and share it. Yes, so here.
Hello, Ma. Don't worry. I think I am going to be able to share my screen now. I am going to be able to share my screen now. Let me try and see how to do that. Ready? All right. So can you see my screen now, channel?
Yes, I'll turn off my video. There is some issue with my on net connectivity on my end also. It's better if I turn it off. So please continue.
All right, channel, please, you can go ahead. Your screen is on. Oh, she's having network issues, but I'm sure she will be joining us back shortly. Just channel. Channel, are you back with us? And please, if you can see my screen, you can go ahead.
Okay. I think I can see the screen now.
All right,
All
please
right,
go
good
ahead.
afternoon, everyone. Um, The topic for today is preparing patent application, parts of the patent application, and patent drafting. So patent drafting is basically preparing the detailed patent, the structural details of an invention and the process of making it. Yeah. So for a patent application to be prepared properly, it requires the combination of legal expertise and the technical understanding of the invention. So a patent drafter cannot sufficiently draft a patent application if they do not understand the technical aspects of that invention. Again, whenever a patent is issued to an inventor, it it may be reviewed over the years, either through when there's an infringement and now you have to go to court. So because they're reviewed over years by public officials like the patent examiner, the judges, the business partners, or even the competitors of the inventor, these people should be the audience you should have in mind if you're going through with your patent application. Please, I would like you to go to the next slide. All right, the patent search technique. These are basically strategies employed for a thorough examination of patent information to find out if the patent has already been invented by somebody else or whether it forms part of prior art. So the first technique we can use is the keyword technique. Now, the keyword technique is basically using different keywords that relate to the invention, and most of the time using synonyms that are relevant to those keywords. For an example, you can decide to invent a smart water bottle, and in your search, you put in a smart water bottle. You can also put in a hydrating tracker because it is something very similar to it. So when you search them together, you'll be able to get a proper, you'll be able to get proper information as patent information that is under it. All right. The second search technique is the classification search. This one is basically using the classification codes, and these classification codes are alphanumeric symbols that are usually attached to patent documents by the patent officers to categorize them by their technical subject matter. So if you're able to use the classification code to make search, it streamlines your results. This technique is usually used by experienced patent searchers or experienced patent lawyers in order to find a streamlined patent documents or patent information on that invention. The next is combining keywords and classification code search. So you can combine using keywords and the classification codes for it. Another thing is using inventor search. So this is basically identifying the key players in a particular invention or in a particular industry, and basically searching for the inventions they've made so that you can understand how to draft your claims in order not to infringe on their own rights or on their own patent. Please, can we go to the next page? However, I would like to state that, all right, for the advanced method, we have the citation search. This can be forward or backward search. So it's basically referencing either patent applications or patent information that were done in the past, or patent information that were done, in a newer time. So that's just basically what it means. I have also explained the inventor search, which is tracking the key players of an industry and making search on their invention. We also have the data and metadata search. This is using the bibliographical information of their patent information to search for a particular patent information concerning a particular invention. Also, tools like Google Patents, eSpaceNet, Patent Score, they actually help to do your patent search. So when you are going on with your patent search, you can use the Boolean technique, which is basically adding and or not or near. This what this does is that if you put two words and you use and or, it kind of brings out patent information that have the two separate words that you're searching for. Again, in Nigeria, the patent information for a lot of patents is not digitalized. So to run or to conduct a patent application, you would need to physically go to the Nigerian Industrial Property Office to actually make a patent search. Can you go to the next page? Sorry, the next slide. Application drafting guidelines. Firstly, we always have to bear in mind that clarity and precision is very important. You always have to put your language, your language will always have to be in a very, very simple form, in a concise form, a form that is not too broad or gives room for ambiguity. Again, you have to fully disclose the patent information. So when you're filing your patent application, you would need to fully disclose the technical aspect of what the invention is. This will enable a person who is skilled in the art to recreate the art. So that is very important to bear in mind. Also, structure. So for a lot of jurisdictions, they might have different structures, but most jurisdictions have like a general structure which includes title, description, claim, and drawing. It also includes, the background information and the abstract. Basically, the abstract is the explanation of your invention, and its job is that it helps people who are doing a patent search to understand fully what your patent is about. Again, consistency is very important. You have to use terms, the same type of terms from the beginning to the end to avoid confusion. Your claim should also be something you focus on, because for patent application, the claim is the heart of the patent application. So you ought to draft it in such a way that it defines the scope of your protection. We also have the support claim, which is basically a claim that backs the main claim. Yeah. Your patent application should also disclose that invention, uh, the invention, it follows the patentability requirements by law. So that is something you would need to have in mind while you're drafting your patent application. Please, can you go to the next page? Right, patent application process. The first step is to file your patent application. You file your patent application through your home country patent office, or depending on if you're trying to do or file an international application, you can also file it through your home office. So the first step is to file to the patent office. Second step is for the patent examiners to examine that patent application to investigate if it follows the patentability requirement, which is whether it is novel, whether it is industrially applicable, whether it is not obvious. So once they review the patent application and find out that okay, it is not really, it does not really comply with the requirements, they could raise an objection, which is the third stage. When they raise an objection, they let you know the reason why they are raising an objection. So I think in the Nigerian phase, they would basically call it a query. So they give you a query, and then you have to respond to that query either by editing or amending your patent application, either in claims or background or whichever part of the patent application that they have a problem with. Then afterwards, they can either grant the patent or refuse it. So when it is granted, they publish it, they disclose it to the public. So this is the patent prosecution process. Please, can you go to the next slide? All right, this is the patent corporation treaty. This is basically a system that unifies the process for filing patent application across a lot of countries. So I think there are 130 countries who are signatory to the PCC. All right. So what this does is that you can use one patent application to gain access to other countries. It does not mean that if you file a patent application in one country, it automatically gives you access to file in. It does not automatically make your patent protected in other countries. So what this does is that it just basically streamlines the process for seeking the patent application internationally. The PCT process is in two major forms, right? There's the international form and the national form. For the international form, firstly, you file an international patent application. You can file that through your national patent office or through the WIPO. All right. Now, obviously, you need to make sure that your patent application includes the necessary parts of a patent application, like the drawing, abstract, all of that. So when it is filed, they will go ahead to they'll go ahead to conduct a international search to discover if that patent already exists, whether they can identify a prior art that is identical to your present application. So when that is done, they usually give you a written opinion as to the assessment of the application. And once that is done, they might likely grant your patent. Once your patent is granted, the World Intellectual Property Organization publicizes that patent. And within 18 months after that first application, you can begin to file in other countries that are signatories to the Patent Cooperation Treaty. Now, because you go through the Patent Cooperation Treaty, you might also have a minimum of 30 to 31 months from the date of your first application filing to claim priority. And what that does for you is that if you had filed an application through the PCT, within that time frame, anything that happens in other of these countries in which you can file your patent application, because there are there are signatories to this treaty, whether there is an application that comes into their office that is similar to yours, it will not invalidate your own application at the time you decide to file it, as long as you're within that 18 to 30 months. So that is what filing through the PCT does for you. Now, the advantages of the PCT, please, can you go to the next slide? Okay. Let me just explain the advantages of PCT. Firstly, it gives you option of a single it gives you an option of single international filing. So you file in one country and you can file in other countries within a time frame. Again, it gives you more time, like it expands your time after your first filing. So for a lot of countries, you ought not to disclose your invention, and even if you do, you ought to file your patent application either within 6 months for Nigeria or within 1 year for US. However, if you file through the PCT, you have 18 to 30 months to go ahead to file in other countries. So they don't consider the fact that it is already, in the public domain as prior art, which will invalidate your patent. They allow you to do that, like it doesn't invalidate your patent. I think that is all. So for our question, please, can you go to the next slide? All right, for our question, what are the most effective patent search techniques and tools for identifying prior art before patent application? Then the second question is, what common mistakes occur in patent drafting that may weaken an application or lead to rejection of that application? Thank you.
I, can I call you Chini, right?
Yes, ma, you can.
Yes. Yes, so your presentation is actually covered a lot of aspects, especially the search strategies, the classification search you went, and you also went for the citations, forward and backward citations. So, forward and backward citations are some thing which we actually analyze in the terms of invalidating a patent application, first thing, and it can also be used in a patent landscape process. So backward citations are something which are filed before your before that present application, and forward are something which are filed after that present application. So generally,
Okay.
to understand the novelty, to negate the novelty, we'll go with the backward citations. An inventive step, to negate the inventive step, I mean, to understand what are more advancements than the present application, we'll go with the forward citations, because forward citations might have something better than the present application because they're filed later. Sometimes it may or may not. So we'll see like, okay, now this application has covered this solution. So let me see a similar context solutions which are filed later with better solutions. So as I said, so that for that we'll go for the forward citations. Okay. Generally in search strategy also, while we are searching general search before we draft a patent, we'll go with backward citations to understand, like, to quickly, because in backward citations it will give the relevant document, so it will also reduce the amount of time for searching in the multiple documents. And forward citations, at the time of search there is no forward citations because the filing date is not confirmed before drafting. After drafting, the examiners, I mean, not even examiners, will see the competitors after filing. So my company's X or Y company has understood like my patent is so and so. Now it can search for some advancements using forward citations from my application. So it can understand the market strategy. So, okay, this person has worked on this and some other people also have worked on it. So let me go something different from which I do not violate these things. So during the competitive analysis, the forward citations are used generally, and in landscape analysis also. Landscape, as I told, like where we have to find out that white gap, where the technology is not at worked or experimented in that area. So for that also we use this forward and backward citations. Coming to the classification search, you said that the advanced attorneys with more experience can go with classification search. That's not actually, okay, but generally we do use classification search. If you could, it's an international patent classification that is a general book. And also there is a cooperative patent classification, CPC also, that will go a bit deviation. So there are different classes. So at least you can start checking with the first main classification, because there are very sub classifications, multiple level of sub classifications are available. So you can at least go with the main class specifically. And if you read it quickly, if you find your invention falls in any subclass, you can give that code also, so that the search results will get reduced automatically. So you can just go with the book, because there is a very simplified classification PDF which was shared by PCT. You can go, and we also have an additional codes. Like some countries, they have their own coding system. Japan people have their own coding system, and it is very detailed. It's very detailed. For each invention, they have a separate codes. In IPC and CPC, it's a cluster kind of thing. But in Japan, that's they are giving for individual things, individual codes are given. So it will give more specific and appropriate results if you use those codes. So as of now, Japan has its own classification code kind of thing. But generally, the PCT also will fall IPC and CPC codes for search. So these 2 points are done. And your first question is, what are the appropriate database we can go? I recommend eSpaceNet. That's actually good. I mean, it will reduce your time. If you add multiple number of fields, now I just, in the previous example, I just showed 2 keywords. But if you add CPC classification, IPC classification, also the numbers will be reduced automatically. And forward and backward citations are something which you cannot keep it in the search fields, that you have to individually check. And that is actually possible in Google search database. So in the Google search database, if I'll just give you a quick, I'll share a document. Okay? I can share my screen now. Okay. So in Google Patents, let me quickly give one application number. Just let's go with same thing. Food processor. Okay. You'll be getting number of things. If you open this document, see it here also the food processor is highlighted. The keywords are highlighted. And the next thing, if you could see, go down the document, you can see the citations. Family to family citations is something which is filed by the same applicant, multiple applications in multiple jurisdiction. That is a cluster of family which is similar, same application. And this is a cited by. This is a cited by means this is a forward citations. Okay. And again, similar documents. There is an additional thing in Google Patents is that it has a section of similar documents. Like these are not cited, like this particular documents does not fall in backward or forward citations, but this also similarly express the same technology. So it is a kind of additional list which you find in the previous list. So you can quickly glance through it. And these are the legal events. If you see for this particular thing, you can quickly check whether it is granted or not, if it is in force or not. This particular legal events is checked when we are actually trying for freedom to operate search. So freedom to operate search is only done for active patents which are alive. So we'll only search which are alive patents, which are already closed and lapsed when 20 years is done. Once a 20 years period is done, the patent application can be, it's a free to practice anyway. There is no need to take permission from the particular applicant also after the 20 years. So it falls into the public domain and anyone can freely utilize that patent application. So for freedom to operate, we'll check only the alive patents because we have to take a proper permission from the applicant if we want to practice that without filing our own patent. Okay. So if there is no kind of applications existing, then he is free to operate in India or in other country. So US application, as I said, he did not file in India. So he wants to manufacture the same food processor in India. So we searched for a similar application in India. Luckily, it was not filed in India by the same applicant or a different applicant with a similar design or similar functions. So that particular applicant has quickly adopted that filed application into India and he started manufacturing and doing his business. So it happened. So sometimes, see, again, coming to the PCT, this actually also, if we check for the PCT, the main advantage is it's stretching the timeline of filing international applications from 12 months to 30 to 31 months. So you're entering the national phase after 30 or 31 months from the filing date. So you have an additional this much amount of time for you to conduct a proper market survey. You can analyze the market. You can see, okay, in this country also my invention might be useful. So if you feel this is useful, then file it in that particular country. And in some scenarios, what happens is you need some raw materials for your invention, and that raw materials you need to import from other countries. So if you feel that instead of if I file this particular application in that country where we source those raw materials also, and in later stages, if you file it and protect it in later stages, if any company in that country is interested to practice my patent, you can actually license to him. So actually you're protecting there also. You're increasing your scope. You're increasing your monopoly. You're increasing your market size. So in this way, so this is the main thing the PCT helps. And coming to the international search report, which is generated by the PCT, it actually it has two purposes. First thing, it will show where your invention stands in terms of novelty or inventive aspect. Second thing, you can decide once looking at the search report, if you feel that it is actually good to go, then you can enter into the national phase. If you feel no, I think this doesn't work out well, you can leave it off before running into the national phase. So these are the two advantages or utilities of the international search report. And the written opinion is a very detailed thing. It will explain that why this particular application is cited as a prior art. So what are the similarities between your and that? So it gives very detailed report, and that is a written opinion. And search report, it will give you the number of applications. Do I have a search report shown? I think for American. So I'll show you the search report, how it will be. That application is actually a good application. So after going through the search report, we understood, okay, now this is a good application because it doesn't have a very similar documents over here. So so what is the other question you have asked? I'm just trying to open up that peer search opinion and the report to just show you how that actually plays. What is the second one you have asked me the query? I think I opened my document. So the second query is, what common mistakes occur in patent drafting that may weaken an application or lead to rejection? Yeah. Especially while drafting claims, you have to be very careful. That is the main deciding factor. And as you said in one of your slides, that your claim should be backed up with the description. So whatever you write in the claims, that should all already present in the description with proper details. So you cannot give us new keyword in the claims which is not present in the description. First thing. That is a general mistake most of them does. So they use one keyword for in the entire description. In the claims, they might come up with a new keyword. They feel, okay, this is actually giving a better explanation. So please maintain uniformity with the key. So that is the one common mistake happens. And the second thing is where you can see is, as I said, don't put maybe, might be, might, it might happen, may happen. Don't give us some vague or open phrases like may or may not happen kind of thing. You just explain it can be practiced in this way, this way. Even though you're not sure about the results, you say that this alternates are also possible because of so and so properties. We can also use this. That's it in the present tense. And third thing, I told some keywords we have to avoid, and especially the trademarks and trade names also. So when you're utilizing any companies, like you want to explain some product, this happens in the background. So when you want to include any product or a company name kind of thing, and please check whether that is a trademark, a registered or kind of thing, and include that so that you're not violating it in the background section. That is another thing which you can avoid. I think most of things you covered, but mostly depends upon the claim drafting, how well you draft the claims and how well your claims are supported by the description and the drawings, both together. Drawings is not something like we are giving it outright, like something we have to fill up the forms. A drawing plays most important part, and we also provide some disclosure. Like you might give one drawing, like example, the shoe shape which I have shown in the slide. you might give this is one of the embodiments. Don't say that that is the that is the design, because in practical the design might vary. When you actually want to prepare a prototype, the design might vary. So don't whatever in the drawings you are including, just mention them as one of the embodiments or exemplary. Exemplary means examples. It can be in this way. So just mention those keywords. Just you are highlighting that we are not claiming that exact design and structure. Our design and structure might be similar, but it will not be as it is as in the claim. So we have to put those disclaimer contents also wherever it's possible. 3. That's it. Those are things. And I just want to quickly show the search report. Just a moment. Just trying to give that. If I'll share the entire screen, that will be better actually. So as you can see, this is the search report, international search report prepared by the PCTP. So if you could see the table, this is the table. If you could see, there is a category AAA, and the description is given here. What is A and A? So generally we get A, X, Y kind of thing. X is something that document, if we compare with it, there is no novelty kind of thing. And Y is something, a document which has similar probability of similarities is kind of optimum. So, but again, if there are 1 or 2 documents which are cited as capital Y, then there is another objection might arise in some countries. For example, in India, that if we combine 2 documents which have a category of Y, there is a chance where you can arrive to the same invention. So that is a thing. And A is something, it is generally defined the state of art, but it is not of particular relevance. So this particular invention actually has a similar type of, not similar type, some existing solutions, but they are not similar in terms of its structure or design or functioning. It's altogether different. So that's why. So after seeing this category, now this has a good novelty aspect and inventive and industrial steps. So all these categories are good. And now this will give like a, now the inventor or the applicant can decide, okay, my application is really good to go in any jurisdiction, because we are not falling in either X, Y, other categories. We are in the safe zone of A category. So we can go ahead. So this is where how like we can decide on it. Now coming to the, this is a search strategy. If you could see, this is the search queries which was used by the PCT people to arrive. And if you could see, they went with all, in all categories, in all text fields and everything. And this is a number of documents, relevant documents have shades, because they had the examiners will conduct a search just before the filing date. After the filing date, it doesn't matter for them. So the search conducted after filing a patent document should also have an additional field, that is the date of filing. So that it always should be, you have to consider the applications which are filed just before, until before date. So now you assume that now today is 20th March 2026, I filed my application and it went to examination. Now the controller needs to search the documents which are filed on or before 19th only. Whatever are filed in 20th kind of thing, they won't work as prior art, because I filed on 20th. So whatever filed till yesterday, those documents will work as a prior art for the examiner who conducts search after the document is filed. But for us, before filing, we generally don't put any date because we don't know. Today we might search, we might draft and file it after 10 days kind of thing. So we cannot put a date criteria. So it gives all the search results until today, the time. And these are the search categories. You can see these are all the things which have applied by the PCT people at the IB bureau, which whoever is conducting the search here. And the other one is written opinion. Yeah. So this is the written opinion. If you could see, this is the written opinion. So they provide a clear description, detailed description. So they have given three references for us in previous search report. So all this they have mentioned D1, D2, D3. So here they clearly mentioned D1 is considered this, but it fails to show this part. Hence, the structural of the washing machine claimed in your application is not known with respect to D1. So they give a very good detailed description in the written opinion. So this also, after reading this also, we can decide, okay, whether that particular, again, in your document, you have to check essential and non-essential components. So those are two categories. There are two categories of components where you can actually decide whether this invention is good to go or not. If there is any relevance with any non-essential component, non-essential components are things that there are some additional things. Even without putting those essential non-essential components also, your invention works well. But if in the search strategy there is a similarity with non-essential components, then you can simply leave, okay, those are they will be there, but the working of your device is not dependent on those components. So if you find any prior art which is relevant to the non-essential components, then still your application is good to go. In the claims also, we have to actually categorize in the main independent claim, you must include all essential components, and non-essential components are something which are additional factors which may or may not, if you want to include, you can include, but the functioning of the device or the method doesn't change. You will get a good result even if you don't include this non-essential, that you can put in the dependent claims, or you can altogether avoid it, but you can explain them in the description. So always be like Srini has covered, your claims must always be backed up with a description. Even though if you have not mentioned something in the claims also, it's okay. You should describe them. Even though if you don't claim also, you have to describe them in the description. So this is the things, guys. I think I covered up. Any further questions I'll take up.
All right, thank you very, very, very much, Ma. You have tried as much as possible to cover a very, very, very key major aspect of the topic for today, and we sincerely really do appreciate. Bernice, if you have any question for our mentor, please go ahead and ask. I think she has already addressed the questions you people originally sent in. So if there are more questions, please we'll be taking questions now.
If any further queries you want to discuss later in later weeks, also you can email me. I have dropped my email here, so you can just take it note. You can contact me through my email.
All right, thank you very much, Ma. Any other questions will be forwarded to you through your mail. We'll do well to send it to the mentee so that they will be able to have access to it, and they reach out to you when they can. So thank you very much for your time in today's session. We really, really sincerely do appreciate the efforts you put into making these presentations and also showing us through how to conduct search, the key part of research, what are some of the common mistakes that people make when making research, that making a search or filing an application that makes it that makes it inadmissible in that sense. Thank you so much, Ma. We really, really sincerely do appreciate. And I think with that we've come to the end of today's session. Yes, with that we've come to the end of today's session. I hope you all have a wonderful night's rest. Good night, everyone, and take care.
Thank you. Bye. Take care, guys.
Yeah, bye-bye.